Hi everyone, my name is Beverly Allen. I'm a Tacoma-based attorney and I've been practicing law for 10 years. Today I'd like to talk to you about evidence as well as the rules of evidence and give you some pointers for how to draft a good declaration to the court. Now, first of all, what is a declaration? A declaration is your sworn testimony or the sworn testimony of one of your witnesses. And the purpose of a declaration is to assist the court in ruling on a motion. A motion is a request that you are making to the commissioner or to the judge. So with those basics in mind, first let's talk about how to draft your declaration. Now, when you are writing something to the court, it is important to keep the end goal in mind. In other words, what are you asking the court to do? If you're asking the court to make a parenting plan, then your end goal is to help the court understand why your proposed parenting plan is in the best interest of the children. If your end goal is to establish child support, then your declaration should talk about income, why it may or may not be fair to impute income, and other issues that relate to the setting of the child support amount. When you are writing your declaration, it is important that you distinguish between facts and opinion, and it's also important that you avoid hearsay. Now, I'll get into hearsay in a little bit, but first, fact versus opinion. The strongest and most persuasive declarations have a lot of facts. They have facts that you can support with evidence. Evidence can include text messages and emails. It can include reports, and it can include evaluations. So good declarations are going to focus on evidence, and it's going to focus on what you can prove. Your feelings about something, your suspicions about something are not usually very helpful to the court, and they're not usually very relevant. That said, I just touched on a couple of buzzwords that we need to talk about a little bit more. Because when it comes to what are some common rules of evidence that pop up and that you should know, there are some frequently cited rules. So first of all, evidence that is relevant is what the court is looking for. If the evidence is not relevant, it can be excluded. And that's rule of evidence 401. If evidence is cumulative, it's a waste of time, it's too prejudicial, it's too inflammatory, then it can be excluded under rule of evidence 403. Another common rule of evidence that comes up is offers to compromise. That's evidence rule 408. Now, the reason I bring up offers to compromise is because quite often parties will offer settlements on a case back and forth. They might offer money, they might offer parenting plans, all for the goal of settling a case. These are specifically excluded, and the purpose, the policy reason, is to ensure people to reach settlements out of court. So those statements are not admissible under evidence rule 408. Other important areas of evidence that you should know has to do with hearsay. So what is hearsay? Well, it's an out-of-court statement that's offered to prove the truth of a matter asserted. In other words, it's what someone is saying. When you are writing a declaration or when you are testifying, it's important that you steer away from what was overheard or statements that were made to you and focus on what actually happened, what occurred, and also what did you witness. If you follow those guidelines, chances are that you will probably steer away from hearsay. But it's a very complicated rule, and you should read the rules for yourself. Speaking of which, I'm going to share my screen so that you can see how to find the rules of evidence. go to courts.wa.gov/rules, and this is that tab at the top of my screen. If you click on rules and go to rules of general application, you will find the rules that are most commonly used. And for evidence purposes, you will click on the rules of evidence. I mentioned hearsay a while ago. This is something that we spend a long time on in law school for civil procedures, and for evidence. So chances are you do not want, or you will not be an expert just by reading these rules, but these rules will help you very much. If you look under the definitions and what the hearsay rule is, different exceptions. There's a couple of items in family law, which is where I practice most common, where hearsay is most often brought up, and that is statements of the other party and statements of a child. So just briefly on that, statements of another party are an exception to the hearsay rule. So in other words, if you're getting divorced and your soon-to-be ex-spouse makes a statement to you, you can quote them because they are a statement of a party opponent, and that will be an exception to the hearsay rule. Statements that a child makes. Now, this is hearsay. It gets brought up often because parents are worried about their children. Well, what I will say is you should expect that the court probably will exclude it unless it's brought up in a domestic violence situation, which is an exception to the hearsay rules. But in a non-domestic violence context, statements of children can only really come in through medical provider reports, such as a therapist that's willing to have their therapy in there, or through a guardian ad litem. And that last point is very important. A guardian ad litem is a special investigator appointed by the court whose purpose it is to talk to the children and give a report. So if what your children are saying is crucial to your case, ask for a guardian ad litem to be appointed, and that is one way you can get that evidence in without running afoul of the hearsay exclusion. Again, there are a lot of rules. It's important that you familiarize yourself with them. And if you have any questions about the rules of evidence, there are many articles online that you can look at, or you can also reach out to TacomaLegalCoach.com through our Facebook page, or you can call and try to get an appointment with me, or at one of our walk-in Wednesdays where we offer some free clinic hours. My phone number is 253-778-6376, and my website is TacomaLegalCoach.com. My name is Beverly Allen. Hopefully this video has been helpful to you as you write your declarations to help the court understand what you are asking for and why. Thank you for tuning in.